And what is going on, everybody? This is Vinny Miller with Military Law, the strongest name in law. As you all know, we are the authoritative force in employment law, employment law, intellectual property law, e-commerce. These are things we do. We do this 24/7, e-retailers and stuff like this. All right, so let's get down to it. Very short video. One, hit the subscribe button, like what you see, hit subscribe, go to the website, www.millettilaw.com, www.millettilaw.com, and sign up, get to the newsletter, get familiarize yourself with everything. Okay, so a brief little video. Question arose about independent contractors. Okay, in New York, it's going to sound counterintuitive because, I'm sure everybody believes something otherwise. Things have changed since COVID. Things have changed a lot in New York City since COVID. This took effect right before COVID, so now after COVID, it's just, the city is not the same. All right, so long story short, basically, so I was asked if discriminatory practices, and if all the New York State Department of Human Rights laws restrictions apply to independent contractors. The answer is yes. It sounds like you would think no because they're independent contractors, but the answer is actually yes. So under the New York City Administrative Code, Section 8107, it outlines unlawful discriminatory practices. What had happened was back, I want to say in 2019, City Councilman Brad Landa introduced a bill to, I want to say, whatever, like 136, introduced a bill that wound up being signed into law. And what this bill did was it extended the protections of the human rights law to not only just employees, but to also independent contractors and freelancers. So that's it really. So realistically, let's say you're an independent contractor and you have a claim for harassment, a claim for discrimination, a claim for retaliation. You have those options available as an independent contractor. It's no longer the situation that, you're an independent contractor, therefore these don't apply to you. They actually do apply to you. And if you really wanted to, as an independent contractor, if you really wanted to push ahead, you really can. The way the statute works is, an independent contractor is considered somebody who's obviously not an employee. It's a natural person who's working as an independent contractor in furtherance of the employer's business enterprise and is counted as a person for purposes of the statute. It's counted as a person in the employ of the employer. So as long as you're a natural person, you're considered an independent contractor, you're treated almost very similar to an employee. There's another step up under the statute. There's kind of like an enhanced standard for independent contractors. That enhanced standard is 3 things need to be in effect. The employer has to have more than 15 employees. The contractor has to work more than 80 hours in a calendar year, and the contractor has to work for at least 90 days in the calendar year. They don't have to be consecutive. It could be, 10 days here, 10 days here, 10 days here. It could be 40 days here, 50 days here, or whatever the case is. But if you meet those 3 requirements, if you're an independent contractor for an employer of more than 15 employees, if you work more than 80 hours in a calendar year, and you're working for that particular employer for at least 90 days, then for purposes of this statute, you're considered an employee. So, my comment to, considering I represent employers, I am a defense side attorney, I'm a manager side attorney. The golden rule is you want to treat, first of all, you want to treat all employees the same anyway. Don't change how you treat employees based on just their classification of employment, because especially now in New York, that independent contractors can be classified as, independent contractors can be treated in the same way as employees, especially during the enhanced, especially in the enhanced situation where, the employer has more than 15 employees, contractor has worked more than 80 hours in a calendar year, and contractor works for at least 90 days. You want to just kind of save yourself the headache. So the good thing is also, at least for employers, the statute is essentially following the insurance, basically this is kind of like the same language insurance company policies have. So if you have an EPL policy, it will speak to this, which is a nice thing. But, realistically though, as employers, obviously an ounce of prevention is worth a pound of cure. So obviously you just, from the very beginning, you want to just be fair, be equitable, treat everybody the same, treat everybody with respect and integrity, and you'll be all right. So that is the quick, short, fast legal update for today. Again, if you are an independent contractor and you've suffered some kind of discrimination, harassment, retaliation, obviously Military Law is here to help. I represent defense side, but certainly we will certainly help plaintiffs as well, whatever the situation may be, because at the end of the day, that's what we do here. So if you have any questions, obviously leave them in the comments below, leave them in the thread, email us vmaletti@malettilaw.com. More than happy to assist, and we wish you all a wonderful day, and yours in laws, love, and lifts. Have a good day, everybody.